Sí, buenos días a todos.
Good morning to all of you. Thank you for waking up early after the celebration we had yesterday. We will start this morning with an interesting workshop that has to do with the evidence in digital media. And I want to leave you with Lilly Acevedo, who will be conducting this workshop. And this morning, please the presentation, if you're so kind. Evidence in digital media for trademark administrative and judicial procedures, obtention and certification. Magister Army Ferreira, Office of the Attorney General of the Republic of Dominican Republic. Luis Vaz, Elzaburu, España. Sebastián Lovera from Ladas and Parry, United States. The moderator will be Lilly Acevedo from the Office of Prosecutor's Office of Dominican Republic. Good morning with all of you. I'm very pleased to have you all here, and we want to thank you, the double, being able to be here after that party that we had yesterday, to this first encounter that we have at 9 a.m. Right here in the front, there are many spaces available. If you just want to approach us and give us a bit of warmth, we would be pleased to have you here. Just as the introduction mentioned, this is about the evidence in digital media for trademark administrative and judicial procedures, and which are the processes of certification and obtention of these evidences or tests. The format of this encounter is a workshop. It will be a very interesting conversation. We have 3 luxury speakers. It's been a great honor and pleasure to be able to work with them throughout this month and this academical activity. And in a special way, I would like to thank the Committee of Technology, who was in charge of getting in contact with different speakers, opening a space in our academical agenda, and making possible that this desire that some of us had could be materialized. And especially to Rita Blanco from Lilly Asociados, who was a main contact with the Administrational Council. We want to thank you all, my dear speakers. I would like to give you a brief introduction of each one of them. For those that don't know them, can have a brief profile of each one of them. I want to start in the same order that they're sitting here. I will start with Sebastián. Sebastián is from Paraguay. He's located in New Jersey, and he belongs to Ladas and Parry in New York. He's a partner from the firm. His professional practice has to do with the fulfillment, protection of trademarks in the United States and internationally. Previous to his incorporation in Ladas and Parry, he was associated to Zacarías and Fernández in Paraguay since 2005 to 2007, where he was specialized in contentious and non-contentious elements in the topic of banking. In the banking environment, he received his title as attorney with summa cum laude from the Asunción University of Paraguay. He is LLM from the University of Michigan, and he has also a degree in the University of Asunción, and he can practice in Paraguay and New York. Is a great South American, as many of the members that are here of ASIPI that are fanatics of football. His favorite player is Zinedine Zidane. I believe it was curious that it was a French player. I don't know if you're denying your country, but it's great. And what amazed me the most is that Sebastián, this year, run his 10th consecutive marathon in New York. He was number 12, and he's an athlete of a very high impact. And he told me that his wife doesn't give him a lot of spaces with the training, so he has to just handle himself in the marathons. Let's continue with the other extreme. We have Luis Vaz from Spain, from Elzaburu. I don't know if you know, but when a person has a long time in an institution, we say that he's like a pillar. Reading your biography, I realized that you make part from Elzaburu since 1995. You're one of the pillars. Luis received in 1990 was graduated in the 1992 from the University of Comillas. He also has a degree from the University of Comillas. He's an agent of the schools in 1992, and he's an agent of trademarks since 1995. He's also been a professor from different academical institutions, and yesterday he shared something that I believe is quite curious, which is that he is a lover of numismatica. I wanted to invite him to the museum in Bogota that they have here in Colombia, at the side of the Museum of Botero, that has a very interesting collection of coins. If you have any space in one of your trips, please go there. He's a child of 4 children. He calls them like that, but when he showed me a picture, they're really adults. And he loves football. He's a fan of the Athletic of Madrid. And finally, but not least important, my dear colleague, the magistrate Army Ferreira. She comes from the Office of Attorney General of the Republic of Dominican Republic. She graduated from the University Pontificia Católica Maestra, magna cum laude, and she has a specialization, a master in intellectual property, and an honorable mention from the University Carlos III of Madrid. He does have 2 little children. They are small children yet, and she now assumed to rise a 4-legged child that makes part of her family that is called Rainbow. She loves dancing. She's a frustrated dancer, and that's a tip for those of the activity in this night. Whoever didn't pull her out a dance, I can offer her here very gladly. And she loves to ride horse and the life in the mountains. Thank you very much to each one of you for this time that you have dedicated to us, and the enthusiasm and that deliverance with which you have helped me to organize the panel. Allow me to explain the logistics. We will be presenting an initial video just to put you all in the mood of what we will be talking about, because when we talk about digital testing or electronic testing or assessing, I want to give you the idea of what we're talking about. And the workshop, just as I mentioned, will be a conversation. I will start formulating a series of questions, and each one of my colleagues right here will start responding them from their experience. In the case of Luis and Sebastián, we will attend the questions from the point of view of the administrative cases, the challenges that we have on the prosecution, and in the case of Magistrate Army Ferreira, from the topic of criminal cases. So let us begin. And let's pass the general video so we can be a bit more autonomous in terms of what we will be talking about. Very well. The first question that I have for my panelists to begin with this conversation of today is, and as good lawyers, which is the legal basis of each one of your jurisdictions? One of the topics that we spoke about from the first encounters is that the test or assessment in digital media, or the obtention of these tests or evidences, are transversal. Here we will be talking from a general perspective. We will focus it towards the topic of intellectual property or commercial brands, and from certain scenarios we will be able to realize that we have a basis that comes from civil rights or from an objective rule in general, because it is an aspect that touches other matters, not necessarily intellectual property. It's a broad perspective. So let's talk. We will start with the basic legislation in each one of your countries. You can share it with me. And linked to that second question, if in the space of intellectual property, is there any kind of limitation on behalf of this jurisdiction to be able to categorize digital media or electronic evidences? Is there any restrictions in terms of intellectual property, or is it a broad legislation? Are there specific dispositions that are applied into the topic, or how is the treatment? Sebastián, if you want to go first. Let me just see which is the question. Which are the legal instruments or tools that your jurisdictions have for the admission of digital proof or tests? Basically, we need to start with the premise that we're going to be focusing on two topics. First, the prosecution to obtain a registration, and the part of the litigation on the administrational side, not on the judicial side. So in the administration side, which be the Trade Office of the United States, this testings are already contained within the same regulations, which are two fundamentally. I hope you can hear me better. Fundamentally, we would have two paths. One that regulates all the aspect of the prosecution, which means the presentation of a request up to the registration, because we must clarify that to obtain a registry in the United States, you're required to have the presentation of a test or of a use case, and this is where the digital case comes in as a test to be able to prove the usage of a brand, and it's regulated. It's regulated by its own rule sets, and these rule sets or regulations talk specifically about the admission of digital proofs, contrary to what happened 20-25 years ago when internet was not something common, in the sense that nowadays it's regulated the way in which these digital proofs can be admitted as an evidence of use, and which are those requisites for the admission. Essentially, all type of web pages that can evidence the usage of a product through the possibility that the consumer has of putting something in a cart and acquire the product is admissible. And there are only two main requisites that each attorney must fulfill with the purpose of that digital evidence to be admissible, and that eventually can help to obtain a registry. These two fundamental requisites are: one, that the evidence of usage, once it's presented, the requester or the attorney must include the URL, which means the link to the web page, so that the tester, the examiner, if they have any doubts in the existence of that evidence of that evidence of use, can go into the web page and verify the usage of that material. And two, we must verify the date in which that attorney or lawyer accessed that page to determine that the date in which that page was accessed, that evidence was available. Because from the moment in which you present it up to the moment when an examiner revises the page, there could be a time frame that has passed, and the contents of the page could change. Those are the two main requisites that are established in the part of prosecution. Now, in the part of the administrative litigation, understanding processes of opposition or brand cancellation is a bit more complex, because these are processes that are adverse, which means that there are counterparts. And in this case, the way to be able to verify the veracity of this test is regulated by the established rules that are within the rules of civil procedures, which means that these are supplementary rules that basically, in terms of evidence and procedure, they apply the administrational procedures in the administrational site. And aside of this, the guide of the administrative handling has a very specific mention that the digital evidence are completely admissible, but they vary their level of veracity or validity according to certain requisites that we will be looking throughout the slides that we will be observing. Therefore, just to summarize, the instruments are, we have instruments in the part of prosecution, the manual or the internal regulations, and the same will be applied to the part of the litigious parts and the administrational side that has its own regulations. And we always go up to the Code of Civil Procedures that are applied to the federal environment. Good morning to all of you. Okay, as I'm in the new intervention, I just wanted to thank Lilly and to all of you and the ASIPI for this opportunity. And if I'm a pillar, on 4th of October of 2023, it will be the day exactly in which I will have half of my life in Elzaburu. So on October the 4th, I'll have to make some kind of celebration next year. Okay, related to this topic, what we need to remember is that in Spain we have a different type of justice, which means that it has to be corroborated. Whoever manifests something has to prove it. Therefore, if you're going to be taking any kind of documentation or any kind of evidence to the process, you have to give creditation to its authenticity. And there are 3 legal instruments that operate in Spain. The first one is based on our ruling of the European Union that is applicable to the 27 states of the European Union, which is from the year 2014. And the fact that a document has a digital form does not deny its value. What you need to do is to see up to what point that digital evidence has a higher efficiency or efficacy within the process. This rule set from the European Union, what establishes is a legal framework in terms of the way in which you should sustain the process, or which is the environment of activity, or which is the level of authenticity of these electronic signatures, electronic seals, stamps, the electronic services of electronical deliveries, the way in which you send the requirements to the counterparts, and the certification of authenticity from websites. And it also establishes 2 levels at the moment of valuing the scope that each one of these tests might have. If these are evidences that have been attained through what we call being prestators of services that are qualified and trustworthy, in that case, those that are qualified have an aura or a seal saying that they are approved by the government, and the others, or the second one, are those that are not qualified. In case that it's qualified, it's automatically recognized at validity to the test, and if someone demands the validity of that document, they are the ones that must validate and show that it's an illegal document. If it's not qualified, the service provider, the trust service provider in that case, the part that supports them into the process, need to bring an instrumentation to be able to verify the veracity of these documents. This is the first document that is a key factor in the Spaniard system, administrationally and judicially. The second one is a law that was promoted in Spain in the year 2020. It's quite recent, that in a certain way completes those elements that perhaps the rule set of the European Union doesn't contemplate. It's guided towards the digital evidence, and it talks about these different levels of the authenticity of evidences, depending if they are based on evidences that were emitted or structured through a provider of services that are trustworthy, being qualified or not. And finally, the third legal instrument that we have in Spain is the lay of civil judgment, and this of course complements in all the different orders, in the civil order, which is the main one, as well as in the criminal order, in the social, or in the working environment, or in the administrational space. So everything that is not gathered in the norms that are applied, this law of civil elements will start complementing the others, and there it will complement these evidences that are delivered digitally or not. But there is an important point that has an important value. Even if someone makes an effort to be able to provide an evidence, if they don't prove or don't evidence that it's a healthy or valid document, a judge could validate them. So it doesn't mean if a document is not evidenced, it doesn't mean that the valuing will be taken from it. The judge is the one that at the end could give its value and say that it's valid or not. And there's no specific norm over branding in terms of digital evidence. There's only one instruction in the topic of civil law and the process of industrial laws that are based on the exhibition of documents that are in the hands of the demanded. And basically it's to support, for example, sales and distribution channels, but that's the only element that we would have to contemplate that is aside of everything we have spoken. And aside of this, in the area of civil judgment that is related to industrial property, it is applied with a lot of rigor, just as Sebastián was mentioning, the guidelines for the procedures, internal procedures, that the Spaniard Office of Trademark that we have, or the WIPO, the trademark of intellectual property of the European Union, they give us some guidelines in terms of how to apply digital evidence. And all of this begins with a common appliance of these evidences, to have a common understanding in the evidence and the process of resources over the brand, the way that the evidences are presented, the structure in which they are presented. And there is a document that gives some guidelines and orders on behalf of the Institute of Intellectual Property of the European Union that was published just a year and a half ago. And all these instruments and tools allow us to articulate and be able to take a reason in terms of the digital evidence. Well, first of all, I want to thank you for the opportunity of being here in this forum, sharing this space of interchange of ideas. In Dominican Republic, we have a law of electronic commerce and signatures in digital documents. It recognizes the value of these instruments for a civil procedure, and it brings value and recognizes its evidence strength. Now, what happens in the criminal environment? In this space, the state is configured in a way that they try to find the balance between the prosecuting organ, that is the public ministry, which is the one that is in charge of putting in movement the public action, and of course the statal violence amongst the particulars. And we have different normativities amongst them. The law of crime and delinquency in the digital media, and it tells us that all the obtentions or recognitions, immediate recognitions or auxiliary documentation have been to subscribe to the procedure that is demanded by the criminal processing of the Dominican Republic. Now, the spinal cord of the criminal process is the principle of legality, and this will of course point out all the path that this evidence must have from its recognition or immediate verification that the prosecutor's office does with all its legal offices, as the obtention, preservation of all this chain of custody of this evidence, and the consecution towards a tribunal for its consecution. Now, which is the environment of application of all these elements? It's general. In the legal space, the code of legal process must be analyzed, because everything that we do is mandated by this code of criminal processing. And the consequences of not observing this procedure would be the annulment of that evidence, and that is, it doesn't have any kind of evidence to be able to show amongst the judge the theory of a case. Now, what will determine the final destination of that evidence, the way in which it is obtained? Now, does this impose a limitation for the topic of intellectual property? No, there's no specific limitation. that are demanded on the consecution of this topic. We just need to look at the rules that are demanded in the regulation, and amongst them we have the supervision and control that the prosecutor's organ of the state has for an important figure that we have, which is the judge of guarantees. As our main objective is to show an evidence and be able to destroy any kind of false evidence that the other side or counter side could be showing. We need to control this figure, which will give the legal aspect to all our acts, and it helps to certify everything that is obtained from these different procedures, and that it may have a juridic effect throughout the process. Okay, so taking what we were mentioning, you already introduced this topic through the entities of certification. And when you mentioned the guidance or the general guidelines that we have so that the test derives as a valid matter, allow us to go more in deep in this topic of validity. And from the legal point of view, how is this presented to the judge of guarantees to validate them? So let's try to talk around which would be these requisites that are demanded by the rule set, so that electronic or digital evidence that we have extracted is not declared as invalid, so it can be admitted. Is that administrational procedure or a legal procedure? Which are those requisites? Which is that attention to detail that we need to have for the extraction of the test or for the extraction of the evidence, and that it may be admitted in a valid way. Okay. Just as we mentioned before, there are 3 legal elements. None of them makes a reference about when these evidences are not valid. What they do is that they articulate the media to be able to show in which way we can present the document in the process so they're valid. And the jurisprudence are the tribunals. Those are the ones that will be defining when an evidence can be valid or when it's not valid. But they don't make very big dissertations. They just say that they need to be presented in an established term that's clear. That's why we have the process of rule sets that define the terms. They say that the evidences must be pertinent, which means to be brought into the process with interests over the topic that is being discussed. If it talks about different topics, the evidence won't have any kind of validity. And just as it's logical, the evidence must respect all the fundamental rights, all the procedural guarantees. It must respect the right to honor, intimacy, and the image of the family. And as a counterpart to all of this, that the tests or the evidences or the admission must not cause an inadmission, and it shouldn't cause the detention of the part that's presenting the evidence. There's no juridic establishment. It's just an establishment of criteria based on sentences of the Constitutional Tribunal of Spain. Same thing happens in the United States, right? Just as we were mentioning in one of these encounters in the process of discovery, when is it's understood that it's valid, that it respects that right of defense, that they don't put in a state of indefension to the other one, that you can give disclose to all the information, be able to reveal it, just to put it in Spanish, that you may reveal all the information so they're in conditions of defending themselves. So what's the treatment that it has in the United States, and what's your experience with the USPPO? Yes, it is correct, and it's very similar to what Luis was mentioning. Obviously, it has its procedural distinctions, but in this case, the American procedure would vary a bit in terms of those procedures that are followed in those countries that are based on the civil right or in the Roman rights. But in the process of parts where I am against an opponent or requester, the admission of this digital evidence is intimately linked it's intimately linked in the way that this evidence will be introduced in the judgment, in the court. It could be valid, no problem, but it must always respect the procedures. And it has a bit what we were discussing about with Army yesterday. It's like we talk about the long-hanging fruit. In the moment of the admission of the evidence, that part must always respect two fundamental aspects, which is indicated, which is the URL that I had mentioned before, and when was that digital evidence accessed. Within the processes, within the litigation, or in that process of litigation, we have the process of discovery, which is the process of obtention or discovery of evidence. Just to give a bit of context, we have an opposition over there. There's not necessary to include anything written or to add any attachment next to the digital evidence. In this case, the only element that will come out are those rights or arguments that will be developed on the part of the judgment, which is a very different stage of the process. We receive the answer to that opposition or cancellation, and after a conference amongst the different parts, we will go into what we call the discovery peers, which was where we start discovering the different evidences. And this is where, just as Luis mentioned, we have to start proposing these evidences. How do you do this? There are 3 or 4 mechanisms to obtain evidences, which are the most traditional ones, which are the requests of interrogations, the requests of documents, requirements of admissions, and also the testimony that happened throughout the discovery process. This is where the different parts, be it as an opponent or requester or whatever the side you are, must start moving their threads to obtain these evidences, so that afterwards, in the procedural process, that evidence can be accessed for the next stage in terms of judgment. In the process of discovery of these evidences, one of the parts have to obtain this information or must make the other part to recognize that information. For example, in a request of interrogations, me as the position of opponent, I can request the person that is making the requirement to look and verify the existence of this web page that was attached as attachment 1. Now the counterpart will have a mini procedure where that part that is receiving that requirement must answer within a term or a period, and that response will eventually be used by the other part in the next stage, which is the stage of witness gathering, where this evidence must be introduced within the procedure, or else this evidence will not be considered by the player or by the parts. And this part of evidence discovery is where we obtain this digital evidence. They make the other part to recognize it or not, and finally we have we gather the testimony on behalf of the other part. It must be notified, and within the notification you put a note of the copy of the web page as an attachment 1. Just to give an example, it's on attachment 1, where through the testimony gathering they show the requester to admit or not the veracity of their contents. Once they verify the veracity of the content, this test will be pre-validated, because within the next procedural process as an opponent, I must make for this evidence to be admitted through a notification that is presented amongst the tribunal at the different parts, that is known as notice of reliance, which would basically be a notification alerting the different parts that I will be using this evidence for the effect of positioning my request in terms of opposition, or well, whatever it is. This is where we call the part of the admission of this evidence for the process. So it comes from the different parts. The parts that wants to propose this test must move the threads so it might be recognized by the counterpart or objected by the counterpart, and then they must move their threads in the next procedural stage to establish the basis for this evidence to be admitted and considered by the magistrate or the organ that is administrating the case. Okay, is there a catalog to admit or not an evidence? Well, in criminal procedure, it's a bit different. We will never aspire to someone admitting an infringement. We have to demonstrate it. The first stage of investigation is completely unilateral and secret, and we only discover it in front of the judge of guarantees, which is the judge of instruction. That's why I was talking about the topic of looking for a balance of the state amongst the particulars, or the civil side. So the first stage of the process of investigation is strictly unilateral, and it depends on us. That's where we start collecting the evidences, so that whenever we are in the process per se, we can have all the different fundaments for these evidences to be valid and show the guiltness of the accused. There's no catalog, as you might say, but the legal code establishes that when we see all the different rules of the procedure that the same code designs, that rule could be admissible or admitted into judgment due to its simple reading. Nonetheless, the topic of the sample, let's say that the legal part is divided in different stages: the preparation, intermediate, and judgment stages, aside of the resource stage. But in the preparation stage, the code establishes that it's a secret for the third parties, which means that amongst the different parts that are involved in the process, there will be an initial stage that will be completely secret in terms of the Ministry of Public Affairs and the judge of guarantees. That's where we go to not fall into what we call like the law of the poison tree. That's where we have to shine, and everything we do will be shown throughout the process. And there is a criminal part, because when you test that an evidence has been affected by the lack of observance on the part of legality, usually the part of defense will start applying that doctrinary part of the theory of the poisoned fruit, of the poisoned tree, and they try to invalidate that evidence part. In this case, the principle of legality will be strictly necessary. Very well, so let's go to the topic of obtention. We must remember that these are WhatsApp messages. These are electronic catalog or e-catalogs. This is information that is in the web with some product. These are images. How do I extract this? Which are the legal mechanisms so that information that we find in a phone, that's in a hardware, a computer, in a database, in a web page that's running at the moment, or in a web page that I verified but wants to be unmounted and I need to extract it. What mechanisms exist to be able to make this digital, be able to move it from a paper, and be able to present it in my administrational process? Okay, if you will, I may continue. So what I just said could be seen as an introduction. So how do we obtain the evidence? There are different scenarios that we can have in digital evidence, and it's that in a physical procedure, in the environment of a registry, we can find electronic devices that could have digital evidence. The second scenario is that the infringement is exclusively and naturally in this digital environment, and that the findings are seen in a non-tangible way. And the third scenario would be that whenever throughout the process, one of the parts proceeds to offer evidences from their side without being part of that initial preparational stage. So in the first scenario, which is the most common one, which is the physical scenario where you obtain digital evidence, there are many situations that may happen because the prosecutor will move or won't go into a private place or into a private property without a judicial authorization. Everything that is used within this procedure must be legal, because they observe the principle of legal procedures. Nonetheless, everything that is obtained in that framework of that operation that was of course that was managed by the judge of guarantees, and it's legal. Everything that is found in that place, they find evidence, but what happens is that throughout time and with the active participation of the defense, in Dominican Republic, it's jurisprudence that even if there was a physical registration with authorized in having sieged electronic devices that could have digital evidences, we need to proceed to have a second judicial or legal permissions for the extraction of the information that is there. So how is this obtained? The siege is legal due to the legal authorization, but it will become illegal if the extraction from those computers are done illegally. So you need, for each step, one thing is to obtain the devices. When you do it physically, when you go and you obtain these electronic devices, and the other one is to obtain the information based on the extraction that is done on from that device towards the digital content of that device. That's two legal procedures, and of course are observed by the principle of legal procedures as well. So with these legal tools that I was mentioning before, towards the end, in a certain way, there are evidences that are born with a kind of blessing in terms of legal procedures. And if it's demanded, it must be demanded with the proof of why it's an illegal document. But where do all these all these documents born that are given by all the service procedures that are legally qualified? I believe that there was an element where we could see how this was structured. This is the webpage of the electronic side of the ministry in Spain, where we have established in the first place which are the norms that are applied, and afterwards we have a session to consult on behalf of those qualified electronic service givers or procedures. And I have one that is called caller juries. We see a series of services that they give, which are services that are related with the certification of web pages in terms of browsing, or it could be contract documents or emails, or it could be certifications related to with other documents that can operate in a network. And this supplier has an act of certified browsing for desktops, and it allows, at a price of 25 euros, I believe that's the price, it allows you to pull out some screenshots of whatever you're seeing in internet, and automatically that screenshot will help to accredit the legality of that documentation that is being observed. And the other option is to record a video of all the browser, procedure, or that operation in the browser, and that is legalized. You have the possibility of taking screenshots, or you also have the possibility, I'm sorry, these are the different categories we have and the differences that they have. There are some browsings with sound, others without sound. The price depends on this. And of course, they can also be installed in mobile devices to be, for example, to record, for example, of WhatsApp messaging, or even making or consulting a web page or something. It doesn't have to only be done through a personal computer, but it could also be done through our mobile devices as well. Those that don't have the blessing that are given by those qualified service providers, you'll go into the system to see that if they are rejected, you have to give other proofs or other evidences, and those evidences would be traditional. And I believe that Sebastián just mentioned one of them. You could ask the counterpart if they recognize that that's a WhatsApp conversation that they have had. If it's recognized, it's good. But you could also give an analysis on behalf of experts where you facilitate the device, and there where we have that documentation or that information that is being rejected. And we can even ask the judge for the counterpart to exhibit their own mobile devices to be able to see that effectively there was a conversation in WhatsApp or in any system of instant messaging. The judge can make a judicial approval of a device. The judge can visualize the device, and afterwards we could ask for the intervention of witnesses. So when you don't have the blessing of these mechanisms that have been shown, what you need to do is to articulate other proofs or other evidences, and in this case the part that is giving these documentation must give those other paths of evidence. There's that's the difference between having a qualified service procedures or not. In the case of Color Beauty, it's one of those companies that are certified on behalf of the government, right, to obtain all the information or data that is done through the platform. So, by principle, we might say that everything has been obtained in a valid way. Yes, that's the ideal. It has a cost, and normally it's only used in criminal procedures because that's where the difficulty of the evidence is higher. But amongst the Office of Patents and Trademarks, we don't do these kind of elements, or in WIPO, because they are less formal at the moment of understanding and reading how the evidence is being presented. And in your experience, I believe it's very clear how we obtained the evidence through these platforms. So in those cases of a high profile at a judicial procedure. Yes, in criminal procedures or dispatch, the equipment that makes these kind of works, yes, when we make counterfeiting or other elements. The problem with internet is that it's ephemeris. What today could be a URL, tomorrow perhaps is not there. What has a content of a part or a counterfeit good, tomorrow when you look for it, perhaps it's not there. Or if you ask the judge to make the validation of a web page, sometimes he could find that that page has already disappeared. Army, here we have an example that you had given us for the presentation, if you want to explain it. Yes, this is the scenario that I previously explained. It's a physical registration where we found electronic devices, and then we asked for a second judicial authorization to extract them. In the other scenario, where the evidence is intangible in a digital way, we try to conserve the data, which is basically what the platform that my colleague just presented uses it. That's the use that we also give in the Dominican Republic. But it being an state or an institute of the state, we use the webpage of the Interpol. These are the tools that we use to be able to preserve that information that's in the web. And if they take away the page, we can already have that evidence already gathered and documented. Within this authorization, the judge resolves to grant or not to the public ministry the permission, the authorization of extracting all the information that has been contained within the electronic devices that we can see here, which are duly identified correctly, and that means part of the chain of custody, with the purpose of not having any kind of breaking of the chain of custody in terms of the extraction of these devices, because the chain of custody implies that the evidence must get ideally to the person that will be judging from the moment that it was collected, going through all the treatment that is given, through to all the technical, electronic, and digital equipment, up to the obtention of the data that has been obtained, and until it gets to the judge. As the public ministry is not in charge of making this forensic analysis, there must be a chain of custody that is observable, where we can see who is responsible, who touched that electronic device throughout the procedure, with the purpose of having the validity of that evidence. And do we have in the United States any equivalent to color duties, or how would that be? Oh, we would love to have something like that. That's what I was saying with Army. It would be great because it really facilitates the procedures, and the costs are not high. Just 27 euros for high outcomes is not so expensive. I would like to have that figure of public notary with the same capacities of giving public witnessing to certain documents that we have within the countries that are based on the Roman law, because the public notary in the United States does not have any kind of study of the law. All the attorneys that are practicing are essentially notaries. When you pay $60 to be able to avail a document. But this doesn't exist, honestly, and all of this falls over the back of over the shoulders of each one of the parts. And there's a high rigorosity for an evidence to be admissible. Well, it requires a lot to have an admissible evidence. Is complex in terms of the form, the procedures. Everything is very well structured. And if one part does not follow those steps of procedure for those evidences to be admissible, the other part could challenge it. And the eventual case that one of the parts just sleeps down and doesn't object something that has been done according to the procedure, that's where that objection, well, won't be valid. There won't be really an objection, and that evidence that shouldn't be admissible will become admissible. So it cannot be done. It cannot be challenged in any point of the stage. There's a specific point where I have to object it or challenge that evidence. If I just sleep over and don't challenge it, I'll lose my opportunity, right? Yes. Throughout the discovery period, when I receive a request of interrogation or a request of revision of documents, I have 30 days to respond to that request, and within these 30 days I must manifest in a written way, because that's how it's done. I must mention the objections or the arguments for which I'm objecting the production of this object. If I don't establish that objection, or I don't write down that objection, I am essentially, I am just waiting that objection, and that's basically the point of processing within that cycle of evidences. And there's another moment where that evidence goes into the part of witnesses or of testimony, and that's where the other part also has a way to challenge the way in which this evidence is admitted within the process through a testimony. There's an aspect, Sebastián, that as a matter of fact we were talking about in one of our recent meetings. Something that you mentioned, and it has to do with the capacity of the USPPO. Amongst that evidence that is being shown to make proactive admissions, to be able to verify that it's valid and that it was obtained correctly. Can you tell us a bit about this? One of those topics that we were talking about were those differences that exist in the criminal process and also in the Spaniard process, of how proactive can the evaluator or the assessor of the Office of Trades to be able to give a step moreover and be able to see if the evidence was obtained in a valid way, or do they only have to accept whatever was presented? If they have fulfilled with that process of legality, if they are ensuring minimum guarantees. But that's one of those processes that we were mentioning of the capacity of the evaluator. Could you expand about this? It's applicable, especially in the part of the prosecution where the examiner has the faculty has the faculty that whenever one of the parts presents as a use case a web page, the requisites would be the URL and the date of access. So what happens? The reviser, and this is just to give a bit of context, I believe that all of you know it, but it is important to mention that to obtain the registration of a brand in the United States, we need to bring credit to a usage. We must prove that that brand is being used in the United States. And in this case, the examiner has broad faculties to be able to revise the document that is being presented. If there's any kind of doubt, the reason for which this URL is included is for them to be able to go into the web page and effectively revise if the products or services that they are mentioning that are being used are effectively being used. These faculties that were given to the examiner are relatively new. They have been applied from 2018 and ahead. It only has 5 years, and as a cause, it has the fact that there's still a rupture in terms of the rights or the regulations from the Office of Trademarks in the United States due to elements or litigations happening outside of the United States, especially based on requests, for example, that could come from China, where the requesters or the legal or the attorneys, the local attorneys, were sometimes making themselves appear as representatives of the United States or attorneys of the United States, so they made the request electronically directly from China, and they sent tests or samples of use that were manufactured or were done with the purpose of obtaining the registration. What this caused, we're not talking about 10 requests, we're not talking about 100, we're talking about thousands of requests that have been requested from China. This basically showed that we were stuck in the processes of revisions that from a moment passed from being from 4 months to 10 and 12 months because the examiners were overwhelmed with the quantity of requests that were coming from China. And as the revisers did not have that capacity to check and object, it would fall into the different parts. The parts had to objective at the moment of presenting a position, and also to the effects of canceling that registration due to a fraud. So from 2018, what they did was not to delegate this to different parts, and instead of this, they would give more weaponry to the examiner. So whenever they receive a request and they give the sample of use, and there's any kind of indication that it could be manufactured with just the purpose of obtaining a registration, the idea is for them to be able to have the power to object or to challenge or reject this petition and be able to release all the process without needing for a part to present a cancellation or position. That's where we have the origin of why the examiner has that legal faculty of revising and challenging or objecting the digital evidence. Luis, can the examiner reject also an evidence in Spain with that faculty? They could do it. They could do it, but usually at the moment of dictating a resolution or a decision, when it gives a greater or a lower value to the documents that have been brought to a procedure. In a judicial procedure, we could articulate evidences and we have to resolve beforehand if the documents are admitted or not, sometimes in terms of the form or in terms of the content. But in a topic of requirement of brands in Spain or the European Union, that usually doesn't happen. And if it happens, the system that has to be applied in Spain is the law of civil judgment, which is a auxiliary law. But in my whole life or my career, I have never seen a procedure where they have opened a stage of testing to be able to look documents that have been already given. The examiner simply takes its decision. If they want, they will proceed. Okay, great. And what happens in Dominican Republic? Well, in the legal part, there's an intermediate stage, and in the preliminary the preliminary judge in the intermediate stage is the one that is the great examiner. He's the one that assesses all these elements of what we have given. He validates the validity of these evidences, of all the different expert analysis, and he judges the evidence. That's a fundamental step to be able to convalidate all the previous steps and be able to project which will go into the judge with the different judge. So everything that is done in a preparational stage can perhaps mark all the process that will be coming. In my country, it's called a sedazo. It's where we filter all the evidence. That's the intermediate stage. And the great judge, which is the judge of this stage, is the one that values which are those evidences that have observed all the procedural rules that have been established by the legal or criminal process, and it decides if it goes into a deep judgment or not. This image that we can see here is an example of the report of experts from the extraction of information from electronic devices. This figure that you see there corresponds to the authorization on behalf of the court, and it must contain all the different characteristics that the order has compared to the report. If there is a failure in terms of the serial number of an electronic device, could derive in the invalidity of this evidence extracted from this equipment. Perhaps we could understand that within the legal process, the freedom of the evidence is always in our favor, but in the topic of the digital environment is so strict that the freedom of evidence does not apply. It has to be revised carefully due to all the different steps and requirements that it may contain. This is a technical report. This is within the other scenario where the evidence emerges intangible. This is an email confirming a purchase in a website that was offering counterfeit goods, to call it in a more criminal way. This person was offering in digital platforms goods of a specific brand, and when the brand was bought, he would send an email confirming. This case was born digitally, and it's treated digitally, so we asked to the judge of instruction and authorization to be able to look at the platform and follow the course and trace of that email confirmations with the purpose of establishing the IP and verify the source where the birth of this case was done, and identify the author. Here what we're identifying, or we're differentiating the criminal process from other administrational cases, because when we have this report to present it amongst the judge of the intermediate stage, we know the who, when, how, and specifically the how is what we need to verify, and always try to pass it specifically how we want to the deep judgment. There's a technical procedure done in the case of the Dominican Republic. Is there specifically an entity like ELICAT? Yes, it's a certifying entity. We only have at the level of public action a certifying unit, which is the Department of Crimes and Delinquency of High Technology. And at the moment, they're doing two functions: the function of collection, which is the operational function, and the function of forensic analysis. It shouldn't be, but that's the reality. And within the expert analysis or report, one of the demands to be able to pass the filter is to be able to say in the report which were the media used or the technical tools used to be able to attain the outcome or the result. The report must contain this specifically for the judge to be able to read in a more understandable way the final results or outcomes. And also with the purpose of giving an enabling quality to that report, we offer as a witness the expert that made the assessment of the electronic device that obtained the evidence to reinforce that expert analysis and report. Yes, I believe that you're mentioning an important aspect in the sense that you just mentioned that the report must declare which has been the procedure or the tools that have been employed on behalf of the expert to extract data. Therefore, this has a direct link to the validity of the evidence. If we challenge a procedure, the program, or the technical base to extract that what's up, that electronic catalog, the dismounting of the page, logically the evidence will be challenged completely, and in this case the judge in that intermediate stage could de-estimate that evidence. Yes, that's why the normativity establishes in the forensic report to see which are the methods that are used on behalf of the expert, with the purpose of having a better reading of the outcome and be able to take care of the validity of the final outcome, which is the extraction of the digital side. If the premise is wrong, the outcome can also be wrong. Okay, Luis, we have a video on your behalf. If the person of technology could give us support, please, with the part of certifications in Spain. Luis gives us here a very interesting and graphic material of what's happening in Spain for this procedure. It is true, it's very important to be able to certify the time and the content of the web pages through these elements that I was mentioning before. So I have brought a couple of examples. One of them are the documents. So we can see the W94 and 95, so you can see which is the certification. This is the case of a certification from a screenshot. And if you observe, I don't know if it's more clear, but the part that has a clip on your left, I don't know if we can see it here in the PDF. I think it's not possible to see it, but what it has, and that's the key of the certification, if it was possible to see it, and it's that on the left there's a clip. When you deploy it, it shows the content of what's been certified, which are the dates, and most importantly 3 or 4 screenshots that may be obtained to credit the infringement that could be happening or the usage that is being done on behalf of a Brown. And there's a second one that had been prepared, but I don't know if we'll be able to see it. It's the N204, where instead of having a screenshot, what we do is to have a certification of content. In the end, the external part, I can't see it here, I'm sorry, we can't see it here because it's an image, but there's also the clip, and in that clip you can even see the video of what's been all that process of browsing that is being certified. That allows us to see exactly how these queries have been done through internet, and even get to the point of the infringement. And more importantly, there are moments when a person types down web pages, but sometimes it's redirected towards a third party, and that's where we have an infringement. If we take a screenshot, we can see the web page of the third party, but we don't see the name of the original domain. Therefore, this is the video. This is an example of what's being certified. This is the browsing process, and you can see where we have the counterfeit products, and this has a background, or is supported under the certification, and the content of this certification, not only the timestamp, the date when it was obtained, and which is the content, but it also has all the screenshots, videos around it. You can stop the video if you will, it was just to show it. And this way it's easy to bring into the process documents that are a complete evidence, and in this way, in this case, the challenge of these evidence will be much more difficult on behalf of the counterpart. So in the obtention of digital evidence, I believe that Spain has a mile ahead, the envy of all the region, because perhaps they have obtained or achieved something that we all aspire. And with that tool, throughout that video that you showed us, it really ensures an important factor, and it's to be able to extract the information in real time. You use a term that is real, and it's that the internet is ephemeral. It could be here, and half an hour later perhaps a web page doesn't exist anymore. So the way to extract the information, or having the information at first hand before it was dismounted, is very important. And just to close the last intervention, And this is because the United States has a particular process for the prosecution or the registry of the brands, and it's that from the beginning we need to credit the usage. We spoke just a while ago about those initial evidences. One of the examples that we joked with in some of the meetings were that before, to be able to make a request among the USPTO, we would require an item or physical evidence of the product, and how this has migrated towards photography. Sebastián here helped me as a model of hands with one of these small packages of coffee cream that we had around the tables in the dining zone, and how this has migrated from sending a physical sample and it has transformed into a digital sample. I don't know if there's any kind of special observation that we should make with this, but some time ago we had the registry of a boat. They showed simply the image of the boat because how can we send a boat physically? Is there any kind of difference in terms of the accreditation of these digital evidence in the contentious or administrative process to the simple prosecution, due to the aspect that from the beginning, to be able to pursue the registry, I need to accredit this usage, and now I am doing it essentially through digital media? Here's a particular example, a particular experience for me was that when I joined the dispatch, that was in 2009, I went into a room where we kept all these evidences of usage. Being a fanatic of U2, that band, nowadays the new generations don't know which band that is, but I remember I found a box with all kind of things, you know, t-shirts, these LPs, cassettes, I don't know, caps, and those were usage evidences that had been used a long time for a procedure or a trademark, and it was old. It was a huge room full of evidences. So I just stare humbly to say, okay, is there any usage for this? Because I'm seeing that it's only occupying a place, and they said, well, no. So I kindly offered myself to alleviate that load and take it to my house, and up to the date I still have that material, that evidence home. But yes, before you required all these physical evidences, they were big, occupied very big spaces, and now with the coming of all these new kind of evidences, digital evidences, and the admission specifically within the regulations that are acceptable nowadays, you can see that that's not required. The future generations will not have the possibility of taking evidences to their home like the possibility that I had with that U2 material. Today, I always tell the clients that the admission of an electronic evidence is completely possible. I do not need you to send me an evidence to obtain the registration saying that the brand was commercialized, that it was imported or received in the United States. The only thing I need is for you to take this coffee cream package. I only need you to take your phone, take a picture, and send it. That's it. That constitutes a use. Obviously, the product has to be commercialized in the United States for it to be valid, but in terms of the material of evidence, you don't need anything further than that. Now, the usage is a fundamental requisite to be able to obtain a registration. There's possibility of obtaining a registration without a usage, but eventually you'll find that obstacle at the moment of maintaining the registry or renewing the registry. So be it now or later on, you will find yourself with that obstacle. And we also mentioned the existence of evidences that were manufactured with the main objective of obtaining the registry. This is a clear example of an evidence that was manufactured with the simple purpose of obtaining a registry. To the right, we can see the product in red that has the part below in red. That's the original product of Lululemon. You can see that it's the same product. It's a deodorant. It's a cylindric deodorant. And this was presented for Lululemon with the effect of demanding the usage of their brand in terms of the deodorants. Now there's a third one. That between parentheses, well, this was a real case where the requester presented the image of the left as an example of usage. This is not a picture taken with a product. That's not a real product. That's a digital image of the product. And we may see when we start analyzing with care the elements of this product, we can see that absolutely everything is identical to that sample of usage that was presented by Lululemon, with the exception that they replaced Lululemon with a brand that is called Max Out, which was on the side. Afterwards, we can see the location of the words, the disclaimers, absolutely everything is the same. This is an example of a use sample that was manufactured with the purpose of obtaining a registration. Obviously, they could obtain the registration. This is just an example of a brand that is currently registered, but it's susceptible of cancellation due to counterfeiting. It would be very easy for me to show that this is a counterfeit usage and cancel the brand. They could have obtained their original purpose of obtaining the registration, but this won't last too much. Have to wait up to 3 or 4 years to start with a demand of this, because I can show this fraud due to a bad faith action, and this of course will make us do a petition of cancellation due to a fraud, because at the moment of presenting this proof they knew that this was a fraud. I do not need to attach this in my request of cancellation, but throughout the process of discovery is where I will be introducing, and I will have to follow all the different procedures for this evidence to be admissible, and finally to be able to obtain the cancellation of the registration. In this case, they're evident, and the owner of this brand didn't even want to go into the court to defend something that is absolutely undefendable. Very well, I only have 7 seconds left on my watch, so I only want to thank you all for your participation, for your enthusiasm, for your professionalism to be able to access this panel. I would also love to thank the presence of my bot, the General Procurator of the República, Miriam Herman Brito, that is there amongst you. And I want to thank the presence of all of you and that bravery of waking up early today after that tremendous party we had yesterday. Luis, can we open a space of Q&A? Or if someone wants to take the advantage of these excellent panelists, well, this is your moment. Okay, in the absence of questions, I just want to mention something else. Luis, who is a great fanatic of Atlético de Madrid, presented as an evidence the page of Champions League. I have noticed that there is no reference to Real Madrid, which is one of the greatest winners in the Spaniard league, and that's just to avoid him being mentioned. Nah, you didn't see the year of that test. That was a year where other teams were playing the finals, so I didn't want to. Just as we say in Spain, and it's an expression that perhaps sounds horrible in some of the jurisdictions, but that's what we say in Spain. And that's just menting the bicha, like pronouncing the name of the devil. But yeah, I wanted to avoid that. Okay, so we have a slight present for all of you. Allow me to go down the stage for a moment to be able to give you this present. And once again, I want to thank you for your presence in the Council of Administration, for admitting this topic that was presented by the Committee of Technology. And I hope we have a nice day. We will keep on seeing each other later on.